Okay, good morning everybody. Welcome to today's licensing hearing in relation to Harefields Duncote. My name is Richard Woods. I am the Democratic Services Officer for today's meeting. In order to get business underway, could I invite a proposer and a seconder for a chairman, please?
I would like to propose Councillor Anne Addison as chairman, please.
I'd like to second Councillor Anne Addison as chairman, please.
Thank you, everybody.
Fantastic. Without further ado, I hand over to Councillor Addison to chair the hearing. Thank you.
Thank you, Richard. Well, good morning, everybody. My name is Councillor Anne Addison and I represent the Harpole and Grange ward. Can I introduce you to the other two members of the hearing panel today? Councillor Barnes.
Thank you, Chairman. I represent the Tove ward.
And Councillor Bambridge.
I represent the Silverstone ward.
Thank you. So we now go on to item 2 of our agenda, which is declaration of interest. Have either of my two colleagues any interest to declare?
No, Chairman.
Well, thank you very much. So we will now go on to item 3, which is the premises license hearing. Well, good morning, everybody who has joined us. Have all parties received a copy of the agenda for today's hearing, please?
Yes.
All right. I think it would be a good idea if you unmuted when questions are asked. I think it would be very helpful, please. Are there any preliminary issues anyone wishes to raise before we start?
Yes, please.
Mr. Golter.
There are only 4 identified objectors on the agenda. I understand that there may have been other people who've written with objections whose letters have been, for one reason or another, rejected. Will we be told how many letters of objection were rejected?
Thank you for your question. Can I come to Richard Woods, please? Richard, have you any idea how many other objectors there were and letters that were not taken into account?
Thank you, Chairman. My role is simply to publish the information that's given to me. I have published all information relating to the objections that's been passed over. I think that would be more a question for licensing, if I could hand over to them as to how many objections were received that were not valid.
Stephanie or Nick?
Thank you. So we put forward the valid objections only, as that is what is required under the Licensing Act. I don't have a current list of all the ones that were submitted, but I can certainly get that if that is required.
Mr. Are you satisfied with that reply?
I didn't hear Stephanie Broomfield's answer, I'm afraid. My machine isn't very clear, but perhaps you could tell me, Chair, what she said in summary.
She can obtain the information if required.
Right. I think it would be very helpful to the subcommittee to know how many objections were raised which for one reason or another were deemed invalid, including, for example, an objection from Greens Norton Parish Council.
I think from a legal perspective, it's a matter for the licensing authority to consider whether or not representations received are relevant. Therefore, if the licensing department have deemed representations to be irrelevant and therefore not for consideration by the licensing committee, the number or content or author of irrelevant representations wouldn't be a matter for consideration at this hearing. Whilst it can be information which is shared post the hearing, the licensing committee are tasked with considering relevant representations.
Thank you. Mr. Golter.
I have to accept that. I'm not happy with it.
Well, thank you very much. What you said has been noted by all of us. Thank you very much.
I have one other very quick question.
Yes,
If
Mr.
I may, and it really is very quick, those of us who are allowed to make presentations to the committee, is it for a maximum of 10 minutes or is it for 5 minutes? We had documents that stated both.
Richard.
Each objector has 5 minutes to address the subcommittee, because I recognise that there are a number of objectors and each objection may be more nuanced and may be different. So each objector will receive up to 5 minutes to address the subcommittee.
Mr. Golter.
Thank you. I finished.
Thank you very much. Well, we will proceed. The hearing is in respect of an application for a premises licence from Harefield Craft Cider Unit 2, Lakeside in Dunkirk. And I'm going to invite the licensing enforcement officer to speak first, please. Stephanie.
Thank you, Chair. So yes, I can confirm we are here today to consider an application for a premises licence in accordance with the Licensing Act 2003 for Harefield's Craft Cider Unit 2, Lakeside, Dunkirk. Lakeside is a private farm with external buildings used for commercial entities. One of these buildings is occupied by Harefield's Craft Cider, who have applied for a registration of a food business with the council in July 2020. An application for a Licensing Act 2003 premises licence was submitted by David Chambers to South Northamptonshire Council on the 9th of July 2020 and accepted as complete on the 24th of July 2020. The initial application was for sale of alcohol on and off the premises, Monday to Sunday, midnight to midnight, provision of films on and off the premises, Monday to Sunday, 9 AM to midnight, live music on and off the premises, 8 AM to midnight, with recorded music on and off the premises, 8 AM to midnight. The full application is attached to Appendix A. Amendments were made to these timings following discussions with our environmental protection team to the following. Sale of alcohol is Monday to Sunday, 10 AM to 1 AM. Provision of film inside is unchanged, however outside is now Monday to Sunday, 9 AM to 11 PM. Live music inside is unchanged, however outside is Monday to Sunday, 8 AM to 11 PM. And the recorded music has remained the same. In considering the representations received and what is appropriate for the promotion of licensing objectives, steps the subcommittee can take are outlined in paragraph 6.2. When an application for a premises licence is submitted, the applicant must display a blue notice at or near the relevant premises and advertise the application in a local publication no later than 10 days after submitting the application. The consultation period runs for 28 days from the date after the application is received. This gives interested parties and responsible authorities the opportunity to make representations in relation to the application. The responses from responsible authorities are as follows. Child protection, no response. Planning, no objection. Environmental protection, no response. Fire, no objection. Health protection, no objection. The local health authority was no response. Police have no objection. Public health licensing was no response. Secretary of State, no response. And trading standards, no response. An additional condition was agreed with the local police force and the applicant, and they are attached to Appendix B. After amending the timings, the applicant also offered the following additional condition, which is no admittance after 11 PM for the provision of alcohol is permissible. We have received objections from members of the public, and they are attached to Appendix C. The applicant and interested parties submitting the representations have been invited to attend. At the end of the consultation period, the licensing authority must hold a hearing if relevant objections are received, unless the authority, the applicant, and each person making a representation that agree a hearing is not necessary. It must take such steps as considers appropriate for the promotion of the licensing objectives, which are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. The steps the licensing can take today are to grant a license subject to the conditions as appropriate if it is considered necessary to promote those licensing objectives, exclude a licensing activity, refuse to specify a named person as a DPS, or reject the application. And that concludes my report today, Chair.
Thank you very much. We're now going to hear presentations from each of the parties. And at the end of each presentation, you will have the opportunity to ask questions. I'd be grateful if you would keep questions only on the matters that you've actually heard.
Excuse me, Chair.
I would now like to invite the objector to make their presentations, please.
May I go first?
Mr. Golcher, do.
Thank you, Chair. You will have read my letter and I will not repeat it now. My objection principally relates to the hours, the inclusion of music, especially amplified, the numbers of people and consequent noise. This comes under the objective of public nuisance. The original application was very wide-ranging, and even as amended, it permits live music outside until 11 at night, 7 days a week, and from 8 in the morning. Alcohol sales until 1 a.m., as well as the noise of people departing by road or on foot, likely including over the fields. My near neighbour will have written her letter with her concerns about noise. She is within earshot and knows that noise carries from Lakeside. But you won't have seen her letter, it was rejected. I would not describe the site as in open countryside, quote unquote, as stated by a licensing officer. The application is seeking extended hours which are too long, and the application is too open-ended. The licensing department in written replies has referred to permissive legislation, or in a letter to me, permissible legislation. This does not prevent limits being placed on what is permitted. It does not mean that, quote, the applicant must be given the opportunity to run the business and prove that they can comply with the licensing objectives carte blanche. Indeed, the Home Office guidance to the Act states, with reference to public nuisance, the approach of licensing authorities should be one of prevention. I shall not take up further time on this point. I know that you members of the subcommittee are well experienced. I shared time with you, albeit some time ago, when I too was an elected member of South Northamptonshire Council, and I was myself a member of the licensing committee. My second point of two, in my letter, I also raised concerns about public safety, specifically the issue of exiting the premises. Customers will be leaving as late as 1 a.m. It will be dark. Leaving by car on a narrow single track road, on foot as above and onto a fast country road with no footpaths, all unlit, or quite possibly over the fields, although there is no immediate adjacent public footpath. I believe this raises safety concerns. In my letter, I referred to the Home Office guidance. In her reply, the licensing officer wrote, quote, the conditions offered by the applicant complied with the Act, unquote. I have read nothing on mitigation of safety concerns in this regard. I have asked for clarification, but have had no reply. My objection on the grounds of public safety stands. In conclusion, the application is too wide-ranging. Even with police limitations, there is scope for large numbers, long hours, alcohol sales beyond midnight, 7 days a week with music. If there is merit in a limited application with reasonable hours, numbers, noise, and access, let that be approved. Additional activities of more extensive nature should be the subject of further application at the appropriate time in their own right. And let me just add, if I still have a few moments, I note the letters of support which came to us yesterday. I never realized so many people from so far afield read the Toast Focus magazine. Let me just comment on one letter from Mr. Chambers' landlord and neighbour, Mr. Pentland. Mr. Pentland writes that he is content with, quote, background music, with small numbers, 20 to 30 people, limited frequency, cultured events, in his words, all of which have been assured to him by Mr. Chambers as being his intention. My view is this: let any license be for such activity as that clearly defined, and as I say, additional activity of a more extensive nature should be the subject of further application rather than this extensive and open-ended application that we see today. Thank you.
Thank you, Mr. Golcher. Could I invite one of the other objectors, please?
Caroline Trotter.
Thank you very much. Good morning.
Good morning, everyone, and thank you for listening to my objections. The first point that I would like to raise is the late publishing of Appendix 4, which arrived by email from Richard Woods yesterday at 3:25. On inspection, all the supportive emails in Appendix 4 are dated 6th to the 9th of September. I'm very concerned that there may be two rules running here, as we were told by Stephanie Broomfield, the Licence Enforcement Officer, that the objections had to be in by the 24th of August. And in fact, I have an email of objection written by Amanda Brown that was submitted on the 26th of August with a written reply from Stephanie Broomfield stating, and I quote, "Your comments are out of time and unfortunately we cannot accept an objection now. I would be grateful to receive an explanation at some point." My understanding of the situation is that this application is based on the granting of a premises licence, which in turn allows the provision of films, amplified live and recorded music inside and outside, plus the supply of alcohol without the need of any other licence. Mr. Chambers has admitted in his application that although, and I quote, "the initial concept is for 20 to 30 people, he could envisage expanding the concept to larger audiences, and in the summer months, a midnight finish would be required. Concerningly, this premises licence could allow up to 500 people to attend at any one time and drink alcohol for up to 16 hours. Using this as my base point, I would like to make the following objections according to the licence objectives set out in the Licensing Act of 2003. I speak on behalf of myself and those whose objections were deemed unacceptable, including those of the Parish Council. The prevention of crime and disorder. Although the applicant has stated that his, and I quote, "initial concept is for 20 to 30 people to attend these events, it remains possible for up to 500 people. The site of Harefields as it stands today on the map attached to the original application dated the 3rd of July can no way support this number due to insufficient parking, dangerous and limited access, and proximity to the fishing lakes only 150 metres away. The possibility for crime and disorder when the attendees could have been drinking alcohol for up to 16 hours is extremely high. The Rock Foundry is a very successful business and is within 20 metres of the site in question and is vulnerable to criminal and disorderly acts should this premises licence be granted. Public safety. Firstly, as stated above, the site in question is 150 metres from the fishing lakes. Also, the access tarmac track off the Caswell Road single track with no pulling in points, which could result in up to 500 cars queuing along the unmarked, unlit Caswell Road in both directions. The Caswell Road at this point of access has a maximum speed limit of 60 miles an hour, with access to Field Burkett Farm opposite, the Flower Farm, field accesses, the turning to Dunkett, and entry to the hamlet of Littleworth, all within 500 metres. The Caswell Road has no markings, no pedestrian walkway, no street lighting. I draw your attention to section 182 of the 2003 Licensing Act, which states that the committee assessing the licence application must ensure safe departure of those leaving the premises, and this you most certainly cannot do. As the site stands, there is also no provision for evacuation in the case of fire. The prevention of public nuisance. In public law, the definition of a nuisance, and I quote, arises from an act that endangers life, health, property, morals, comfort of the public, and exercise or enjoyment of rights common to all. In this case, if a premises licence is granted, then the possibility of amplified music blaring over the peaceful green fields of Dunkett, Littleworth and Greens Norton would undoubtedly endanger the public's right to the enjoyment of rights common to all, i.e. the peace and tranquility of living in the countryside. For many, this may also affect their mental health, causing unwarranted stress and unhealth. The Rock Foundry are also entitled to the enjoyment of rights common to all in the running of their very successful business. Point 4, protection of children. The adjacent fields to Harefields Craft Cider is owned by Mr. and Mrs. Davison, who are establishing a flower growing business, which will incorporate an education centre for children. This has been warmly welcomed by the local primary and nursery schools. By granting a premises licence under the criteria of this one, will most definitely affect the Davisons' community project, as the footpath to Greens Norton from Harefields goes across their land and directly interferes with the area designated for the education of children. To conclude, I would probably not object to this application if the licence wasn't as wide-ranging as it stands today. Perhaps Mr. Chambers should reapply with a narrower application. Thank you again for your time.
Thank you very much. Can we hear from the third objector, please? And who's that going to be?
It can be me.
Thank you.
Thank you.
We just have your Christian name. Do we have a surname, please?
My name's Alice Rock, and together with my husband, we own the premises Rock Foundry, from which we run a successful family business for the last 40 years. I note in Steve Petnam's letter of support that he claims to be the nearest neighbours to the units. In fact, we're the closer neighbour, with Rock Foundry being only 10 metres away from the units, making today's decision critical to our established business. First, I'd like to state that I'm not opposed to cider making or selling business running from the units, We've seen many varied businesses come and go and have never objected to any of them. However, I do object to a licence being granted that would allow a venue for up to 500 people up to 7 days a week. Although David Chambers has stated that the initial concept is for gatherings of around 20 to 30, he does go on to state in his application that he envisages opening up to a larger audience. Once the licence is granted, the larger audience would cover up to 500 people. At the moment, I'd argue the units are not up to the standards required to host 30 people, let alone 500. I'd like to see full inspections of the premises by relevant authorities and the correct planning permission put into place before licence is granted. Otherwise, I can foresee this venue would have a detrimental effect on my land and buildings, and more importantly, jeopardise the health and safety of ourselves, our employees, and the visitors to the venue. As stated in my letter of objection, the key areas I'm concerned about are as follows. Planning permission. I do not believe there's any planning permission associated with the units, and certainly not of the necessary category to hold events, brew cider, prepare and serve food, or trade as a shop. There must be certain criteria for health and safety and access which would need to be met before premises would gain the requisite permission. Therefore, I do not understand why a licence can be granted when planning permission has not been granted. How can you allow up to 500 people to use a site that's not fit for purpose? Car parking and site access. Access to the property is by way of a single track with no passing places, and cars have to reverse back to Rock Foundry or back onto the Lichborough Road, which is potentially very dangerous if there's a queue forming along that road. It was never intended for more than access to workers of the units or Lakeside House. In the event of a fire, would emergency vehicles be able to access the property safely as cars try and exit? Is it a suitable fire exit even for 30 people? Also, there is not enough car parking space to accommodate even 10 cars for the first wave of 30 visitors. Midweek and lunchtime events could cause access problems to us, our staff, and to deliveries. This could be detrimental to our business. Facilities and environmental management and food and safety hygiene. There are no toilet facilities in the buildings and no hot water. We've had problems in the past with visitors to the fisheries defecating on our property. In light of this being recently highlighted to David Chambers, he has brought a mobile toilet onto the land. This is not plumbed in, and how does it drain as there is no cesspit at the premises? Are these adequate hygiene facilities for 30 people and staff that are preparing and serving food and cider? Are there health and safety guidelines or COVID guidelines that are being breached? There are no waste facilities or organised waste collections from the site. We're worried about site cleanliness if food and drinks being consumed. The units have been subject to rat infestations in the past, and we worry this would encourage further infestations. Some fears would be allayed if we are assured that the premises had been inspected by the Environmental Health or Food Standard Agency before mass catering commences. In general, we're very concerned about the lack of structure around the potential opening hours of the venture. It opens our business up to intruders, trespass and damage, as there is no schedule or specific opening hours. My fears are shared by Emma Davison, owner of Littleworth Flower Farm, who occupies the adjacent property, who is extremely concerned there will be a detrimental effect on her use of the land as a forest school, as daytime events allow music and alcohol consumption should not take place in close proximity to children and vulnerable young adults. She is also concerned about access to the site by locals via a footpath, which could be subject to antisocial behaviour, such as urinating and littering, especially if on-site facilities are not up to standard. Finally, I note that letters of support focused on the brewery business as a whole, rather than having expressed specific support for the licence itself. The support is heavily reliant on David Chambers' good moral character. However, if the licence is granted to the venue, it can be sold on. We can see David Chambers is entrepreneurial, so what would stop him from selling on the licence to someone of a less moral character? Also, Steve Pentland says that he holds the lease to the premises and would not want to upset his neighbours. However, Steve Pentland is also a businessman, and the premises licence would undoubtedly increase the rental value of the property. I don't believe it's for David Chambers or Steve Pentland to regulate the licence. I believe it's SNC's responsibility to ensure that the appropriate investigations have been undertaken and that planning permissions are in place before any such licence is granted. Whilst I as a business owner support the entrepreneurial spirit, I'd urge the panel not to grant this licence to this new unproven venture at the expense of my successful, long-established business. If after thorough inspections the authorities are assured that the site is ready to hold events, then we cannot see why the application for a temporary event notice on an event-by-event basis with maximum number declarations would not be the best way forward for this. We believe these are modest in cost and would be far more reassuring to us as business neighbours. Thank you.
Thank you very much. Now we come to the fourth and final objector, please. And again, could you unmute? Unmute, please. Thank you. And could I have your surname?
Graham Lawrence.
Thank you.
As I start this, I really want to put in context of why I'm on this call today, because my letter, which was included in the pack, itself was not deemed to have raised valid concerns, but in a complaint process which Mr. Sutcliffe here has dealt with, he has recognised that basically I wasn't given the opportunity to voice any objections or raise any concerns, because my concerns raised were said to be taken into consideration, were going to be taken into consideration, but in reality they weren't. I had to complain. I've got the opportunity today, and I'm very pleased and grateful to Mr. Sutcliffe for giving me that, because it's able, let me talk to you today with the benefit of the proposal, which was published on the public website on the 9th of September, which everybody that had been involved in this was dying to see, because the whole framework had been jiggled with and revised by Mr. Chambers without any notification given to anybody who had raised a concern. That clearly means some people may have changed it. I've been able to pick up on some comments by Mr. Sutcliffe, which really supports my point of view in my letter about the venue, etc. And thirdly, we saw the support letters, and I'm going to endorse what Caroline Trotter said. You know, these are all dated on the 6th of September against a process that was meant to have been concluded on the 24th of August, where other objections were actually summarily rejected. Interesting, 99% of those letters say nothing more than Mr. Chambers is a jolly good fellow, which really has gives no traction to the application whatsoever, in my opinion. And the only one that is of any validity is really the one that has come from Mr. Penland, which Jim Golcher referred to, which I will come back to. So picking up on Mr. Sutcliffe's comments, he said in his reply to the complaint that basically concerns need whether the definition of whether a concern has been sufficiently mitigated can't take into account. He said, for example, it cannot be assumed that an application for live music will automatically mean that the operator will cause a public nuisance. Like it cannot be assumed that patrons leaving premises will also make a noise constituting a public nuisance. Now, I agree with that, but from my point of view, as an objector, it therefore cannot be assumed that because the applicant draws a red line around the field, that that he's actually got access to that land, because he hasn't. He's only got a license or a rental for the area surrounding the building. So he's redlined an area which clearly would be far too many for 30 people, and we're more akin to 100 to 500 people, but it can't be assumed that he's got right and access to that and to apply for a license to apply to that land, because it isn't his and he hasn't got a license, a rental agreement for it. It can't be assumed that the owner of the land of the single track will agree to larger numbers using that track. Andrew Nightingale owns that track. I spoke to him and he knew nothing about this application before it went in, and he certainly would not be agreeable to a large number of people going in. It can't be assumed that the applicant will honour his application for small numbers of up to 30 when the field is highlighted clearly aimed at much larger numbers. It cannot be assumed that planning permission will be granted from change of use from a light industrial unit, if indeed that's what it is, to a venue selling alcohol and providing entertainment. It cannot be assumed that the premises, which have no toilet facilities at the application stage, and now as this mobile unit, no kitchen facilities and no established way of disposing of waste, such as a septic tank, will meet public health standards. It cannot be assumed that the site, which is in need of extensive improvement, will provide adequate and established parking without impacting on the foundry that Alice and her husband Dan own, and that the single track road will be acceptable to the Highways Department and indeed, as mentioned earlier, to the Fire Department. So Mr. Pentland has made it quite clear in his application that he's quite happy with numbers up to up to 30 people, which Alice has said she's not, has quite openly stated that if it becomes unruly or it gets into a big estate, then he can actually withdraw the notice. And in essence, to me, rather than a letter of support, that seems to be a letter of kind of covering his backside, really. But he is a businessman, and that they are words, and there's nothing to say that he'll necessarily put that in place. But it's hardly a glowing reputation from your landlord, I think, really, behind this application. So I think where I come from on this is that I was in corporate banking for a good number of years and did a lot of credit applications. And if this application came to me, there's nothing I would put on a tick from it, because even being a nice bloke isn't insufficient for me to say that you'll make a success of the business.
Mr. Lawrence, can I just say you have about half a minute left.
Yeah, well, that's all I need. So my summary is if the committee is minded to grant this licence, I would say that it should be limited to the number of people. It should be on hours that are more akin to a pub, i.e. 9 in the morning till 11 o'clock at night. And it should be subject to planning, highways and public health issues all being satisfied before it becomes live. Thank you. Did I finish in time?
You did indeed. Well done. Thank you very much, Mr. Lawrence. Thank you. Right, we've now heard from all the objectors. So I'd like to know if there are any questions from our licensing enforcement officer, please.
No questions. Thank you, Chair.
Nick, do you have any questions? Nicholas Sutcliffe, do you
have no questions. Thank you, Chair.
No questions at all. Thank you very much. Are there any questions then from the applicant, Mr. Chambers? You're muted. Could you unmute, please?
I've a question to all of the objectors with regards to the single track road. I have spoken to Andrew Nightingale and he has given me permission to use the road. I wonder if any of the objectors are all making the assumption that everybody will be arriving by car, and that whether people have taken into account that bus services to collect people from local communities and local villages may be a service that we would be providing, that people may be able to, if we can attain access with the landowner, walk to the premises, and obviously people can cycle and car share.
That's it, is it?
Yes.
Thank you.
And I'm sorry, also there's just two other things. Just to come on something that the licensing enforcement officer mentioned earlier, I actually occupy 2 of the buildings at the site.
Thank you. Now, can I ask my subcommittee if they have any questions that they would like to put? Councillor Barnes.
No, thank you, Chairman.
Thank you. Councillor Bambridge.
Not at this stage, thank you, Chair.
Thank you very much indeed. Right, now I'd like to invite the applicant, Mr. Chambers.
Chair, could I just ask a question? Are we as objectors allowed to ask a question now, or can we ask it? Do we ask it later?
I think you should be asking it later. Can I just check? If you hold on a minute, can I just check with Richard Wood?
Yes, in accordance with the script that's been circulated, you will have the opportunity to ask questions of the applicant after he's made his presentation.
Later, at the end. Thank you very much indeed. We're going to ask now Mr. Chambers if you would like to present your case. Thank you.
Please. I'd like to take the opportunity to explain a little bit more about myself personally and what I've done in the past as to demonstrate my approach to business, neighbours, local community. I'm David Chambers. In 2015, I launched Harefields Craft Cider. This converted a hobby to a commercial entity. I own Harefields in its entirety. I've built the entire business from scratch on a shoestring budget, from starting with a homemade apple press to its standing today. I live in Greens Norton, a 6-minute walk across a field from the cidery. My neighbours diagonally opposite to my home, back onto Blakesty Hill Road, and then the field that adjoins the cidery. I'm essentially acquainted or friends with the majority of the immediate residential neighbours to the cidery, and some of these are my immediate home neighbours too. A number of these immediate residential neighbours have sent letters of support. It varies season to season, but Harefields presses approximately 15,000 litres of apple juice cider per year. So we are very much a small craft cidery and artisan business. I've been self-employed for the vast majority of my life, setting up my first business at 19 in Ireland, selling to pubs and restaurants. I've worked in telecoms in Australia and set up and ran an ice cream business on the Côte d'Azur in the south of France. It was after competing on the very first series of the BBC's Great British Bake Off, I started Harefields Outdoor Catering. This bakery and race business traded at many outdoor events stretching from Glastonbury to Toaster Rugby Club. I've extensive experience in relation to food hygiene, health and safety, fire assessments, etc., and have always held a 5-star rating with South Northampton's Food Hygiene Department. Up until now, Harefields Craft Cider has produced cider and sold into the trade. For businesses to survive and grow, they have to adopt and change. For Harefields, this means adopting a public on-site business model, similar to what hundreds of microbreweries, cideries and distilleries do across the UK every day. I am not, and cannot emphasise this enough, looking to trade as a public house. At the core of Harefields, it will remain a cider producer. The licence will allow us to sell cider online, sell cider to the public for consumption off-site, and have public on-site for food and cider-related events. The vast majority of these will be ticket-only events, and the majority will be 20 to 30 people maximum. These may include cider workshops, cider tours, cider blending days, food and taste matching, and other food-themed entertainments, all along the lines of the tone of Hugh Fearnley-Whittingstall's River Cottage. If the demand is there and can be safely administered, we would like to hold a very small number of larger events, essentially a summer beer, cider and barbecue festival and/or outdoor cinema weekends. For the smaller events of 20 to 30 people, the food will be a set menu. It will have elements of entertainment, education and theatre in its cooking, i.e. the barbecuing of a whole spatchcock pig for 12 hours over a wood pit will be community dining, people sitting next to people they have only just met in a friendly, relaxed banquet dining environment. The public won't be able to arrive when they want and order pints of cider from a bar. We are not a public house. Since submitting my application, I've always been open to inviting people on site to discuss the application. 3 of the 4 objectors sitting here today did visit me on site, as did Charles Manners, Conservative councillor. With regards to the relevant points raised within my objections, I've listened and mitigated by reducing the hours of provision of alcohol, reduced opening hours, reduced outdoor amplified music and outdoor cinema times. Essentially, I am now looking for 1 extra hour of outdoor recorded background music outside of the standard provision within the 2003 Licensing Act. I've also mitigated concerns of all-night drinking or late arrivals by introducing a refusal of entry after 11 PM for the provision of alcohol. The pub located in the heart of the village and only a stone's throw from one of the objectors has available licensing hours on a Friday and Saturday of 1:30 AM and last orders at 1 AM. So you can arrive there for the provision of alcohol 2 hours after I would have turned you away, even if you had bought a prepaid ticket. In my view, many of the points raised within the objections are not relevant to the promotion of the licensing objectives. However, I would like to address one objection in conclusion with regards to the safe departure for those members of the public using the premises. At the point when people book an attendance ticket on our website, book a ticket and on our website Q&A page, safe departure from the site will be explained, i.e. all taxis will have to be booked many days in advance. If Harefields has arranged their transport via bus, etc., they will be returned to the point of collection. All hedges and verges will be checked for good visibility. Adequate lighting will be provided where appropriate when leaving. Pedestrians will be advised of the dangers and safety precautions of walking along the Lichborough to Dunkirk Road. However, if permission from the landowner is achieved, pedestrian access to Greens Norton could be achieved from Harefields site via the Knightley Way footpath, which is immediately next door to the corner of my site. This would be a walk of 6 to 8 minutes to Greens Norton. I would like to have explained more and in greater depth, but we are restricted on time, but I welcome any relevant questions. Thank you.
Thank you very much, Mr. Chambers. Are there any questions from our licensing enforcement officer?
No questions, thank you, Chair.
Mr. Sutcliffe, anything?
I have no questions, thank you, Chair.
Thank you very much indeed. We now come to questions from objectors. Could you raise your hand? Mr. Lawrence. Could you unmute?
Yes, Mr. Chambers, I'd just like to ask you, you made a categorical statement about the licensing hours of the Butcher's Arms. On their website, it quite clearly states that they're never shut on any day of the week after 11 p.m. I wonder what your observations on that were.
That's their opening hours. And as you stated earlier, that once the license is issued, then they can change. I've contacted the licensing department yesterday and they have sent me the times. And as I put in my statement, they are the available licensing hours of Friday to Saturday of 1:30 a.m. and our last orders half an hour beforehand, which is 1 a.m. They're the times that licensing department gave me yesterday. And may I just reiterate that when applying for a license, that doesn't mean that you will use all of that time. It just gives you the opportunity to have those opening times and serving times.
Okay, well, certainly it's the opportunity, the same as you got the opportunity to invite 500 people. So that really underpins it. I'd just say that we came to see you, Caroline and myself. I just wondered what your reluctance has been, bearing in mind you've told Mr. Pentland that you only want to do it for 2030 and the odd big event, which you've now done. We came to see you. I just wondered what your reluctance is to seek a licence which reflects that and does what 90% of the nation does and apply for a 10 each time you want to do an actual larger setting, which you could then obviously present individually, gain some trust in the community. And I just wondered what your reluctance was to just seek a licence till 11, have the films on, have a little bit of background music, have tours during the day, which I think all four of us would say wouldn't be a problem if it was small numbers and well controlled. But what's your reluctance to actually, why do you want to go for the big bang? Why don't you just go for something that reflects what you want to do and do a 10? You know, a temporary event notice is just something that's done all the while by people who want to do small numbers. And that, Mr. Pentland says, you've assured him you'd only want to do small numbers. So I just wondered why.
Thank you, Mr. Lawrence. Mr. Chambers?
If I answer Graham's question, I think I'd call or sort of draw point to the licensing enforcement officer in some of her correspondence with the objectors. I'm applying for a premises license. I've put in my application the numbers of people that would be at my typical event. The Licensing Act 2003 allows the provision of up to 500 people where an additional license doesn't need. That information that's in the application is something that's part of the 2003 Licensing Act. So,
yes, but I'm
Mr. Lawrence, can I just say, you've asked a few questions. Could I invite any of the other objectors, ask them if they wish to ask a question of Mr. Chambers, please?
Yes, please. Caroline Trotter. I would just like to ask two questions. My first one is about transportation. Mr. Chambers talks about buses and taxis. That still doesn't account for the fact that this is a single track road that comes off the Caswell Road that is unlit. It's got no pedestrian walkway for those that want to walk back or cycle. It's not got any road markings. It would just, and it's got this terrible corner with all these access roads. It is lethal. It's lethal during the day, let alone at night. So that's one thing. And included in that, he talks about walking across the fields. Well, there are stiles, there are fences you've got to cross. So tell me how he's going to light that. Another reason I think it's incredibly dangerous. And my second question is change. You say in the documentation it says planning, there's been no objection. Have you applied for a planning application for change of use?
Mr. Chambers.
Okay, with regards to the fields, I'm not sure if Caroline is familiar as I am. That's my route to work. There are no stiles, there are no fields, there's no stiles, there's no fences or gates that need to be crossed or walked through. There's one as you come into Greens Norton, which doesn't need to be opened. You can walk around the side of that. And if I can just clarify at this point, we don't have the permission of the landowner at the moment. There is one ditch. If I speak to the landowner and we can come to some sort of an agreement for occasional use of that, then adequate safety bridges will be put in for the ditch. With regards to planning, I am in discussions with planning with regards to use of the buildings. Those conversations are ongoing and have not come to a conclusion as of yet.
Thank you. I'd just like to go back to the footpaths. I know there is a footpath from Greens Norton that crosses the Davidson's flower farm, where there is a stile that has to be crossed. Now, I know you're saying people could use the Knightley Way, but many might try and use this route, and the Knightley Way is still unlit, whether there's a ditch or whether it's easy walking. It's still in the dark. So people are still walking back in the dark.
Thank you, Mrs. Trotter. Mr. Chambers.
With regards to the footpath that will be going past what was Richard Selby's property, which Anne Pittam used to rent, and I now understand that it's someone's doing some cut flowers there. The footpath enters the field there, which I believe is Andrew Nightingale's. There is no access from that footpath to Lakeside. That footpath goes diagonally across the field and joins the Lichborough to Dunkirk Road. So there is no public footpath, no public access that takes you past the flower cut place to Lakeside.
Well, that is not what Mrs. Davidson says, and it's her land that I'm talking about.
Thank you very much. Can we now ask Alice Rock, is there anything that you would like to, a question please, to Mr. Chambers?
Thank you. Yes, I almost feel like I'm in a parallel universe here, because the state of the venue that David Chambers is saying is quite different from what I see. Even if you put on bus services, etc., if you invite 500 people onto the property, there is not enough car parking for it, David, is there? There's not enough car parking for 10 people and to have this dining experience outside, because they will all be sitting on top of their cars. It's like I'm very worried about car parking. I'm worried about access. I'm worried about how you're going to stop them parking on my land and trespass and damage to my property. And I'm still, as the other applicants, very concerned about how you are going to manage people coming off that single track and the dangers onto the Lichborough Road.
Thank you. Mr. Chambers.
Okay, as I explained, the vast majority of all of our events will be ticketed events. They will start at a certain time in the evening and then they will finish. That then means that people who are using the single track, even if we had 30 people and they all arrived in individual cars, would arrive in the same direction at the same time. They would then leave in the same direction at the same time. So I reiterate, it is not open to the public to arrive as and when they want. People will all arrive between 6:30 and 7 o'clock, say, and then we'll leave after we've completed the event, say official finishing at 10 or 11, and they can stay on and drink if they wish. So the traffic will not be going past each other at those. With regards to parking, I rent the paddock, the field at the back of the cidery, which could be used for parking. I also have use of the land in front of the mound, which if you look on the plan is sort of in the middle, it runs down the length of the buildings, which you can fit approximately 15 cars on there. I've spoken to Steve Pentland and have use of the car park, which is used for fisheries at the bottom. You can get up to 6 cars on there. So it is quite possible to have at least 25 plus cars along there. With regards to security for the foundry, I suggested at my own cost and my own expense and time to fence off the foundry from Harefield's site. This was initially, and put a gate at the bottom of our track. This was initially agreed with Dan Rock from the foundry, Alison's husband. He even suggested mounting the fence post on his corner of his building, which I didn't want to do. I then spoke to him about this a number of months later, which 2 days later, Dan, in his unique communication style, rejected that idea, didn't want his property to be fenced off. I couldn't really get to the bottom why, other than the fact that there'd never been a gate or a fence there. So I have tried to mitigate that. There is also a gate at the end of the driveway, because at the moment, although they talk about me opening up to security risk, there's nothing preventing anybody walking or driving down all the way to the foundry or to the Harefields building at the moment. Although there has always been a gate since I took property on at the end of the driveway. I've never seen anybody, including the foundry, ever close that gate or lock it at night.
Thank you, Mr. Chambers. Can I ask Mr. Galter, I believe you'd like to ask a question, please.
Just a very quick question. The question of planning permission was raised and I didn't hear an answer.
With regards to planning, I'm in discussion with the planning department. We have communication going back and forth at the moment. We haven't come to any conclusions.
Can I just say that this is a licensing hearing and not a planning hearing. I believe, Richard Wood, you'd like to have something to say, please.
Thank you, Chairman. I was just going to echo your thoughts and just remind everybody that the subcommittee will make determination in accordance with the licensing objectives and not planning matters. Thank you.
Thank you very much. Finally, Alice Rock, I believe you still have a question.
Yes, thank you. I do note that David Chambers says all the time the vast majority of events are for 30 people, which again just makes me believe that there will be events held for up to 500 people if this license is granted. As such, he says that the 30 people coming in will all be going in the same direction onto the property. And 30 people going off in the same direction, but there aren't car parking places for 30 cars.
I mean, is this a question, please?
Yes, I think he needs to admit there are not car parking facilities for 30 cars. He's admitted himself for 25 cars. So, and so that is my question. There aren't car parking facilities for 30 cars, are there, David? And also, it's not true regarding the fence.
Can I just bring in Nicholas Sutcliffe here, please?
Yeah, thanks, Chair. Sorry, I was going to speak before you spoke. I just want to reiterate that a couple of things that are being discussed are not relevant in relation to a Licensing Act application under the 2003 legislation. Number of car parking spaces is irrelevant. It's not a consideration when granting a Licensing Act application. Lighting on roads away from a premises is not a relevant consideration when granting a Licensing Act application. Fencing, etc., not a relevant consideration when granting a Licensing Act application. It is literally the licence application that Mr. Chambers has presented. Any extraneous stuff is irrelevant. I can understand why the members of the public are passionate about those things, but in this case, they're probably more suited to a planning application as opposed to a Licensing Act application. Thanks, Chair.
Thank you very much, Nick. I hope you all understand that. Finally, Mr. Lawrence, yes? Unmute, please.
This is a question perhaps for Richard and Nicholas and Stephanie, but if you were minded to grant the licence today, can that licence actually be used if planning permission does not exist for the site?
Thank you. Nicholas.
Maybe it'd be better from a legal perspective.
Oh, sorry. Yes, I do. You're so very quiet. I've missed you out.
Just
sorry.
That, we obviously the committee can appreciate the objectors' frustrations in respect of licensing and planning, but the licensing committee must acknowledge the proper separation of the two. The licensing policy of this authority is clear that they would normally expect planning permission to be in place prior to an application being made. However, there is no statutory basis on which they can refuse an application if planning permission hasn't yet been granted. If a premises license is granted in the absence of planning and premises operate without the requisite planning permission, then the planning authority would then take enforcement action for breach of planning legislation. So whilst ever the two are distinct, they're not reliant on each other being in place, because if planning isn't in place, planning can prosecute or take enforcement action. If licensing isn't in place and licensable activities take place, then licensing can take enforcement action. Unfortunately, this can't be a rerun of a planning process, and likewise, as and when there is a planning application for which obviously objections can be lodged and there would be a hearing, that can't be a rerun of a licensing application.
Okay, may I just, Lisa?
No, I think we've had a discussion. You've had legal advice now, and I think I'd like to move on to ask my panel members if they have any questions. Councillor Barnes. Unmute, please. Thank you.
Thank you, Chairman. Did you hear me?
You said no questions?
Yes.
All right, thank you. Councillor Bambridge.
No, nothing from me either, Chairman.
Thank you very much indeed. Well, all parties will now have the opportunity to sum up. Please don't repeat your, I'd be very grateful if you didn't repeat the whole of your presentation. I'm going to start with our licensing enforcement officer, Stephanie, if you please sum up.
Thank you, Chair. We have nothing additional to add other than just to remind the steps that the subcommittee can take, which are to grant the licence subject to conditions as appropriate if it is considered necessary to promote the licensing objectives, exclude a licensable activity, refuse to specify a person named as the DPS, or reject the application. And that concludes my summary. Thank you, Chair.
Thank you very much. Well, can one of the objectors sum up, please? Mr. Galter, have you got anything that you'd like to say, summing up?
No, I've made my points about noise and safety, and my arguments remain the same.
Thank you.
May I please? Yes, please,
Yes.
if I may. I would just like to emphasise the fact that this premises application contravenes the prevention of crime disorder, public safety, the prevention of a public nuisance and the protection of children. Thank you. And therefore should be rejected. Thank you.
Mr. Lawrence.
All I
Unmute,
wanted
please.
to say, to pick up on what Lisa Gilligan said, is that wherever the committee puts itself in terms of granting or not granting a licence here, or for what hours, in the light of everything that's been said, as planning permission, as it can't be operated without planning, and if it goes ahead without planning, it will be prosecuted. I once again say that I think it would make sense for everybody, for anything that's agreed, to be subject to to obtaining the requisite planning permission before it goes ahead.
Can we hear from Alice Rock? Do you wish to sum up in any way?
Thank you. Yes, I do agree with Caroline Trotter in that the premises is not fit for purpose. It is not fit for 30 people or 500 people currently. I believe that a temporary event notice on an event by event basis would be a much better way of going forward with this business, especially in light of planning permission having not yet been granted. Once planning permission is granted, I think the licensing could then be re-looked at. But until that point, I'm just extremely concerned about our safety as a business, public safety, and criminal damage. Thank you.
Thank you very much indeed. I think we now come to the applicant, Mr. Chambers. Is there anything you would like to say in summing
Yes,
up?
please. Thank you. Just quickly on that note of temporary event notices, obviously a temporary event notice wouldn't allow me to have off sales or have online sales. But in summing up, I'd just like to be perfectly honest. When I submitted the premises application, I didn't expect to be having to deal with accusations of wanting to be running all-night raves, Glastonbury-style music festivals and late-night drinking dens. At no time have I ever mentioned a figure of 500 or a number similar. I also feel that at some point, some of the points raised within objection letters, not genuine concerns, but people believing they can identify a site-related technicality that will bring the whole application to a grinding stop and prevent the business from being successful, employing people, attracting people into the local economy and paying taxes. Complete NIMBYism. It became apparent from inviting two of the objectors to decidery that they had misinterpreted the timings of amplified and live music and the definition of how I would be implementing this part of the Licensing Act. They believed I was applying for 24 hours of amplified and live music. It has only been people who don't know me or my business that have raised objections. The nearest residential property to the decidery, residential property, not business property, the nearest residential property to decidery, approximately 200 metres away, is Steve Pentland, my landlord. Steve is in his 60s, wealthy and very successful within business. Steve would have a very good understanding of what I am looking to be offering at decidery. Steve is a major investor in the local community-owned village pub and is well known by many local residents and his neighbours. I have spent thousands of pounds and hundreds of hours renovating and developing the site. Within my tenancy agreement with Steve, clauses exist where I could be removed or evicted from the site if I'm essentially not being a good neighbour. Steve, in his letter of support, has described this as an additional community control lever. I also know people in the local vicinity, mums and dads from nursery and Greens Norton Primary School. I'm an adult volunteer within Greens Norton Scouting movement, so know other locals through this. I spend 1 to 2 hours a week with other parents at Greens Norton Children's Cricket Practice, and as I said, I know many of the immediate residential neighbours to the cidery site. Local support for Harefields Craft Cider is essential to its survival. It would be professional and social suicide to be operating my activities in a way that was not sympathetic to all the local residents. I would like to conclude. I believe approximately 30 letters of support were received yesterday, and if the subcommittee haven't already, I would suggest they pay particular attention to support letters from Alaric Neville, Phipps and Northampton Brewing Company Director, local distiller Lawrence Conisby from Wharf Distillery, and Crispin Slee's letter of support, who organises Toaster Food Festival and many other local food and drink events, and in many ways is a local food hero with his finger on the local food and drink pulse. Thank you very much.
Well, thank you very much. And can I thank everybody for taking part this morning. I think the panel has quite a lot of information to digest now. I'm very grateful to everything everybody has had to say. So the subcommittee are going to retire now and to make our decision. And the decision of the subcommittee will be communicated to all of you within, I believe, 5 days. Can Richard Wood nod or shake his head?
Thank you, Chairman. Yes, it will be communicated to all parties within 5 days, 5 working days, that is. So.
Thank you very much. And also details of how to make an appeal against the decision of the subcommittee will also be included. So with that, may I say thank you very much, everybody. It's been a very interesting and instructive morning. So thank you. We will leave you.